Hi guys, I'm going to read out a statement regarding the council tax liability order hearing that happened on the 29th of August. So just bear with me, I'm just going to read it out to you. A mockery of justice, a breakdown of my council tax liability hearing. Introduction. What you're about to hear is a chronological account of a liability order hearing that took place on Friday the 29th of August 2025. This account is true to the best of my knowledge. This hearing wasn't just procedurally flawed, it was a fundamental betrayal of justice principles enshrined in both law and the Council's own constitution. Let me walk you through what happened and why it matters to everyone concerned about fair treatment under the law. The hearing timeline. 1. Confusion over court identity. The hearing began with immediate confusion. The paperwork stated Greater Manchester Magistrates Court, a court that doesn't physically exist. When I questioned this discrepancy, the legal advisor clarified they were calling from Manchester Magistrates Court, not Greater Manchester Magistrates Court. As stated on the summons, when I noted that I had searched for the court named on the summons and couldn't find it, confirmed by both the court and the council, the legal advisor casually explained it was a collection of courts. When I attempted to explore the jurisdictional issue further by questioning if it was a virtual court that doesn't exist as a physical venue, the legal advisor abruptly cut me off with a dismissive, "Well, anyway," and quickly moved on. This cavalier treatment of a legitimate jurisdictional question undermines the very foundation of these proceedings. 2. Refusal to identify. When I respectfully asked for the names of those judging my case, a basic transparency request, I was met with resistance. Most tellingly, when I asked for the chair magistrate's name, the legal advisor instructed me, "No, they're your worship to you." This requirement to use a flattering title instead of knowing who is judging the case directly contradicts the wisdom found in Job 32:21, which states, "Let me not, I pray you, accept any man's person, neither let me give flattering titles unto man." Denial of fair hearing. When I attempted to ask preliminary questions to understand the proceedings, the legal advisor bluntly stated, "We're not going to waste any court time. We're going to hear from the council representative first, then we're going to hear from you." This statement alone reveals the predetermined nature of this hearing. Article 6 of the European Convention of Human Rights guarantees everyone a fair hearing, a right summarily dismissed in those 7 words. Character assassination. The council representative was permitted to make prejudicial statements about me, claiming I proposed free man of the land arguments, an irrelevant characterization designed to bias the magistrates. Despite my clear objections, "Objection, Your Honour, objection," this character assassination was allowed to continue unchallenged. The ignored legal defence. The heart of my defence was straightforward and based in statute. I had twice tendered the full payment in legal tender at the council offices with witnesses present. Under Regulations 34.5 of the Council Tax Administration Enforcement Regulations 1992, once payment is tendered, the authority shall accept the amount and the application shall not be proceeded with. Crucially, a council officer, not the representative present in court, had previously admitted in writing that there was no policy to refuse legal tender, that cash is legal tender, and that there is no legislation saying cash must be paid at the post office. This written admission directly contradicted what was being presented in court, yet when I presented this defence, the legal advisor repeatedly diverted with, "Do you accept that you owe this money?" A question designed to sidestep the legal issue of tender. Misleading the magistrates and the legal advisor's blatant partiality. During the hearing, the council representative made a critical misrepresentation to the court, stating that he has been repeatedly told that that building he has attended cannot take cash payments. This statement directly contradicted the written admission from the council officer that there was no policy to refuse legal tender. What's more, the council representative should have known this statement was false, as I possess an email from parking services explicitly confirming arrangements for accepting cash payment. The email from January clearly states, arrangements have been made for a payment of £70 in current Bank of England banknotes to be accepted by David Alexander at number 1 Riverside. This evidence conclusively proves that the council does indeed accept cash payments when they choose to, directly contradicting what was represented to the court. Though I didn't present this specific email during the hearing, the council representative's misleading statements about cash acceptance were particularly egregious, given the documented evidence that exists. What was most disturbing was the legal advisor's reaction. As an officer of the court whose primary duty is to ensure proceedings are conducted fairly and in accordance with the law, the legal advisor should have questioned the council representative about this critical contradiction. Instead, he repeatedly interrupted my attempts to address this misrepresentation and redirected with questions designed to undermine my defence, like, do you accept that you owe this money? The legal advisor, who is supposed to be an impartial officer of the court providing guidance on points of law, effectively became an advocate for the council. When I clearly explained that the liability was removed when they refused to accept it under the law, they are obliged to accept it, the legal advisor simply responded with, "Okay, thank you," before the liability order was granted without addressing the statutory defence. This display of partiality from someone whose role demands neutrality was perhaps the most egregious procedural failure of the entire hearing. The legal advisor's function is to assist the magistrates in understanding the law correctly, not to shield one party from scrutiny while aggressively challenging the other. The abrupt conclusion. When I attempted to cite Stroud's Judicial Dictionary to support my position, the legal advisor abruptly declared, "The hearing's concluded now." No consideration of my statutory defence, no addressing of the legal tender issue, no explanation of why Regulation 34.5 didn't apply, simply, the liability order has been granted. When I stated this will be contested, the legal advisor suggested I could appeal, a statement that reveals a fundamental misunderstanding of my position, as I correctly responded, "I've got nothing to appeal, there's no liability." Why this matters. This hearing violated multiple principles of justice. Rochdale Borough Council's own constitution mandates that when acting as a tribunal, they must follow proper procedure which accords with the requirements of natural justice. 2. The right to be heard is fundamental to natural justice, yet my statutory defence was ignored. 3. The confusion over court jurisdiction raises serious questions about the validity of these proceedings. 4. The refusal to accept legal tender twice created a statutory bar to proceedings that was completely disregarded. 5. The council representative's statements directly contradicted written admissions from another council officer, yet this contradiction was never addressed. What happened in this hearing wasn't just unfair to me, it represents a dangerous precedent for how authorities can ignore both statute and natural justice principles when convenient. If councils can refuse legal tender, ignore statutory defences, present misleading information, and benefit from partial treatment by court officials, then the protections we believe exist in our legal system become mere illusions. Conclusion. Let me be absolutely clear. This hearing was an abomination of justice. The combination of procedural failures, refusal to consider statutory defences, deliberate misrepresentation of facts, the legal advisor's blatant partiality, and the apparent predetermined outcome makes a mockery of the principles of our legal system claims to uphold. When those entrusted with administering justice show such blatant disregard for proper procedure and impartiality, we must question whether these proceedings serve justice or merely provide a veneer of legitimacy for decisions made long before anyone enters the courtroom. This isn't about avoiding responsibility, it's about holding our institutions to the standards they themselves have established. When magistrates, legal advisors and counsels operate above the law they're sworn to uphold, it's not just my rights that are violated, it's the foundation of justice itself. The end.